Franklin County Commissioners meeting, April 17, 2018.
Well, good morning. Welcome to the Franklin County Board of Commissioners regular weekly board meeting. This is Tuesday, April 17, 2018. Note for the record that Commissioner Cook is here, as well as myself, Commissioner Peck, and County Administrator Mr. Johnson. I have not heard anything about or from Mr. Miller, so I don't know where he would be this morning. Okay, Mr. Miller's not able to attend today. He's out on personal business. So we'll move on. First item is call to order, so we're now in session. And if you would join me, please, with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay. Next item is approval of minutes. We have adjusted our practice here just a little bit of recent. The minutes have been provided to the commissioners and publicly. Are there any additions, corrections, or deletions desired? If not, the minutes can stand as approved. Okay. Hearing no additions, deletions, or approved. Okay, they'll stand as approved. Next item is considering approval for an exception to the minimum lot size for a short plat 2017-04 for Harder Farms Incorporated. And I see that Nicole Stickley is here this morning. AHBL Personal Services Contractor. And aren't we delighted that you're here? I mean that sincerely. Okay. If you would, go ahead and give us a brief on this. And if it's okay, I'd just like to say up front, the only question I saw was, I thought that on the AP 40, the requirement was that you had to have 40 left over after you cut a piece off, not that both pieces had to be 40. So if you could help me understand that as you go through, that would be helpful.
Absolutely. Thank you, and good morning, Commissioners. We just have a request this morning for approval and for an exception to the minimum lot size. So the file number is short plat 2017-04, and this is an application from the Washington State Parks and Recreation for an approval of a short plat. This is the first step in their project. And just by way of background, I understand that since Palouse Falls became named the state waterfall, their visitors have increased dramatically, and so they are looking to create more amenities at the site. Specifically, one of the things they're looking to do is create some overflow parking. So that's the impetus for this request.
Okay.
So this proposal is to divide 640 acres from the Harder Farm and just split off a 12-acre lot size. When we do innovative short plats for residential use, we do have a requirement that a certain amount of acreage be set aside. But this is different. This is not a short plat for residential use, and so we're not going to be able to process the short plat under that provision.
Okay, so just for my own education, if it were a residential division, under an AP 40, I understand that the main remaining piece would have to be minimum 40, and what could be cut off merely needs to be big enough to meet the residential requirements of the zone in the county.
For a minimum density requirement,
right, okay.
Correct.
And so this is different, and in this case, what size do the two pieces have to be?
So they're starting with 640 acres, full quarter section.
Right.
They want to carve off 12 acres, which should be used for this parking purpose. And that's just very atypical for a short plat. And so it needs to come to the commissioners for approval of being below that minimum lot size.
The deviance.
Pardon?
Say for the deviance of the AP 40.
Yes, it's a deviation from the zoning code.
So for a normal non-residential short plat, what would we be looking at as a minimum size?
40 acres
40
would be the minimum, yes.
All right. So we've done administrative plats for just a handful of lots on 5-acre parcels in the donut hole. but those are for residential use. And the distinction here is non-residential.
In a completely different zoning district. Yeah, AP 40 is really meant to be
Right.
conserved in
Okay.
that agricultural
Very good.
purpose. So the one thing I want to mention is that down the road, they'll need to come to us for a conditional use permit for parking, because parking is not one of the primary or secondary permitted uses. And also, my understanding is that the state Parks and Recreation Department will be acting as SEPA lead agency. So SEPA hasn't occurred yet. We haven't looked at a conditional use permit yet. This is simply just the short plat approval, which we will still do administratively in the planning department, but we just wanted to get your consent on the exception to the minimum lot size.
I guess my biggest surprise is why they're stopping with 12 acres for, when they get a busy weekend out there, they line up that whole, what's it, almost 2 miles or better off of Highway 121 or 221 going, people park out on the 221 and have barbecues out there in that dry land and, then walk in, and I'm just surprised that they're only taking 12 acres.
I think 12 acres is all they could get, is my assumption.
Thank you.
Originally, when they came to us, they were talking 40 acres.
Yeah.
Yeah.
Well, I think the way this map shows is probably the topographical problem more than anything.
Yeah. So the requested action today then would, it seems, would presume that we aren't going to have an issue with a conditional use for the parking. Otherwise, it wouldn't make sense to take this step and then later say no permit for parking, right? So
The conditional use permit is a separate process, and it does require findings of fact and conditions of approval.
Right.
And it does require public notice and everything else. So the presumption is not that they've obtained that entitlement, simply that we're approving the short plat, and that it's up to them to obtain the proper entitlements down the road.
yeah, let me rephrase that. I could have said it better. I think for the board to approve this today, we would have to presume that we're unlikely to have an issue with the parking. It wouldn't make sense to go through this administrative
Give
short
them
plan
a
process.
thumbs up and then,
Right, and so, Nicole, I'm understanding that administratively it's necessary for them to clear this hurdle before they go to the next. Okay. It seems overly mechanical and bureaucratic, but none of us made these rules, so be it. Huh? Okay, Commissioner Cook, you have any?
I would move for approval of the exception to the minimum lot size short plat 1704 for Harder Farms, Inc.
Okay, and I'm happy to second. Any other discussion? All in favor, please say aye.
Aye.
Aye. Nicole, this is an administrative process. Really, you just needed our consensus, I take it. You don't actually need a signed resolution or anything.
That's correct. We will continue with the administrative action in
So we'll
office.
go ahead and give that back, and I think we're good.
Wonderful. Thank you very much.
Thank
Thanks,
you.
Nicole.
Okay, next item on the agenda this morning is public comment. There'll be another opportunity toward the end of the meeting after we've been through most of the rest of the agenda. Anybody wishing to provide comment to the board at this time, this will be the first of 2 opportunities today. Okay, not seeing any, we'll move on to office business.
Mr. Chairman, we have 2 papers of vouchers here this morning. First one is fund expenditures, 13 miscellaneous items, current expense, election equipment, enhanced 911 county roads, etc. Bottom line of those items is $528,059.57. And Keith has looked at them, Mr. Beaton and Macy Stein have signed off on them.
Okay, and I'll second on the motion for approval of fund expenditures in the amount read. Keith, any comments, questions, concerns about any of these? No. Okay. All right, all in favor, please say aye.
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 Second and final is salary clearing and emergency management payroll. Bottom line of those 2 items is $740,396.86. and 12 cents, and Mr. Beaton and Royale is co-signed.
Okay, take your motion. Second, any comments, questions on any of these? Keith, anybody? Okay, all in favor, please say aye. Aye. These are approved as well.
With that, I would move for approval of the consent agenda 1 through 13 as presented.
Okay, I'll second with discussion, assuming that there's no items that you want to pull out for separate action.
I have nothing to pull.
Okay. Been through these a couple of times, and Keith and I went through them again yesterday. Keith, we had a few topics that we discussed. Can I assume that we've addressed those?
Yes.
Okay, all right.
We made some brief language change in the first item on the tax title properties, to make that more clear regarding what board action would take.
Right.
When the treasurer would act subsequent to board action. So it's more clear now what's expected.
Okay, most of the others, if not all the others, were more observations on process improvements. So, okay, so a motion and a second for consent agenda. All in favor, please say aye.
Aye.
Aye. Okay, consent agenda is approved as presented. We are well ahead of schedule, so let's go ahead and take a moment to sign these. Keith, I don't think we're ready to start yet with administrative office business, but if you wouldn't mind summarizing for us what items you'll have today. I see on the agenda the Superior Court judges. We'll have a discussion there. I'm presuming that for good reason that's not in executive session, but open session.
Correct.
Okay.
They have asked their appointed counsel, Dale Kimber, to be called by telephone to speak to the board, to make that request on their behalf.
Okay. Oh, thank you. Okay, do we have a particular time that Mr. Cameron is going to be on the phone?
It will be approximately 9:20, so we're ahead of schedule.
Yeah, I thought we were. Okay. And we'll be calling him, will we?
Yes.
Okay. Sounds good. Signatures on that one.
Yeah.
See if we can get this done by 9:20. My understanding is the judges will not be joining us in person this morning. Mr. Cameron will be representing.
That's my understanding, yes.
Is Mr. Sant going to be here? No, don't know. Okay. I saw Craig out there, didn't you? I hope the operating manual for this grader is shorter than this contract.
Yeah. I think the longer I get here, I wish contracts were much shorter.
I think I got all those. Morning, Mr. Sant.
Morning.
We're just about done here, so Go ahead and start.
Good morning. This is Keith Johnson and the Franklin County Board of Commissioners calling for Dale Kammerer.
Sure. Keith Johnson?
Yes.
Wait a minute, 1 moment.
Let them know too that the call's being recorded.
Dale, good morning. This is Keith Johnson, Franklin County Administrator at the Board of Commissioners meeting with Chairman Brad Peck and Commissioner Bob Cook. How are you this morning? Good. I'd like to just let you know for the record that this meeting is being recorded and there are members of the public in the audience.
Okay.
Turn this to Commissioner Peck.
I take it we're not in executive session.
That's correct.
Okay.
Good morning, Mr. Kammerer. How are you?
I am fine, thank you.
You and I have spoken previously on county business, but nothing otherwise. I trust that's true with Commissioner Cook as well.
Also, yeah, good morning.
So on our agenda this morning is the topic Superior Court Judge's funding request for legal fees. And with that, I'm just going to go ahead and hand the opportunity to you, since this is a request from the judges that you're presenting on their behalf, correct?
That's correct. Let me begin by saying I'm making this presentation on behalf of the judges of the Franklin County Superior Court because although they have disqualified themselves from hearing or deciding the current lawsuit involving the court and the clerk, they don't want to make public statements that could be misinterpreted as an attempt to influence the lawsuit. So they've asked that I speak for them today, and I'm making this request on their behalf, not mine.
And Mr. Kammerer,
The judges understand that the prosecutor does not have a budget for outside counsel that is sufficient to fund this litigation. And while the judges are certain that the prosecutor's appointment of this attorney to represent them included authorizing representation in litigation if it became necessary, we certainly understand budgetary limits. Therefore, I'm asking on behalf of the judges that the board fund this litigation for 3 reasons. One, because of the importance of the issues, which I'll talk a little more about in a minute, but 2, because of the clear authority of the Superior Court to control the records of the court, which are maintained by the clerk. And then 3, because of the clear refusal of the clerk to abide by the court's rule on maintaining and providing paper records until transition to a fully electronic file system can occur in a manner that is satisfactory to the court. The issues here are extremely important they concern whether the Superior Court has the authority to control the manner in which the records the court relies on to hear and decide cases are filed, maintained, and produced for their use. These cases, of course, include criminal, civil, juvenile, domestic relations, parental rights, guardianship, and mental incompetency cases, all extremely important cases for the citizens of Franklin County. The cases are assigned to the Superior Court for adjudication, not to the clerk. The case files, which inform and guide the court in making its decisions and then ultimately record the court's decisions, have to be complete, accurate, and accessible in all locations where the court conducts its proceedings. Nowadays, the court conducts proceedings in several locations, not just the courtrooms. And not all of those locations have access to the electronic files. And by the state constitution, the clerk is the Superior Court's clerk and is a subordinate office to the court for the purposes of maintaining its records. The clerk is not a fully independent office. And although the judges are fully in support of making the move to the Odyssey electronic system, that just has to be done with the court's guidance and consent so that its obligations to the litigants and other stakeholders in the judicial system can be maintained. As the Odyssey system now exists for Franklin County cases, the judges do not believe it assures the constitutional due process and other constitutional compliance that the court is obligated to guarantee, and as to which the court can find its decisions reversed by appellate courts if that guarantee is not upheld. Our pleadings in this case, I don't know whether you've seen those or not, but they demonstrate that all of the legal authorities that have considered the issue of whether the clerk or the court controls the court's records have come down on the side of court control. In our pleadings in this case, we supported this position with specific citations, and we attached copies of statutes, decisions of the Supreme Court of Washington, and an Attorney General's opinion, all supporting our position. In brief, those precedents hold that the clerk must conform to the statutes and court rules that relate to his performance of matters that affect the court. This includes local court rules, which the Superior Court is specifically empowered to adopt. We have seen nothing from the clerk that suggests these authorities are not controlling. Therefore, from the clerk's standpoint, his best alternative is to upset this litigation process, which is otherwise headed toward a resolution of this issue in a definitive manner. The clerk's refusal to recognize the court's authority over its records and refusal to comply with the local court rule that expressly directs the court to maintain paper records pending the court's agreement to transition to the electronic system presents a constitutional separation of powers conflict that threatens the administration of justice anywhere a county clerk decides to resist the court's management of its own records. It's unfortunate that Franklin County looks like a test case, but it's only the Franklin County clerk who has taken the position that he has control of the court's records. And other clerks, though, are doubtlessly waiting and watching this county to see whether the court's authority will be enforced. That's what we seek to do in this lawsuit. I'm happy to answer your questions, and I understand that there's been a suggestion that Benton County ought to share in the cost of an attorney in this matter, and I think that probably starts from the premise that operational costs for Superior Court are shared, or a belief that is shared, but that's not completely correct. Costs that are associated with the separate Benton and Franklin courts are not shared. For example, each county pays for its own interpreters, computers, printers, furniture, telephones, courtroom technology, and things of that sort. And there's a significant budget item for those expenditures in Franklin County on its own, and separately in Benton County on its own. Asking Benton County to participate in the cost of attorney's fees in this case would be inconsistent with the historical practice, and it likely would be refused because Benton County's clerk has not refused to accept the Superior Court's authority over the transition to electronic records. They simply don't have a stake in this issue except as a bystander. So, again, let me just summarize by saying I'm happy to answer questions, but I, on behalf of the Superior Court, ask that you authorize funding for this particular litigation. I don't know whether you have been provided with any dollar amounts that we're estimating for this. I can talk about that also.
Okay, thank you. Commissioner Cook, any questions, comments? And
I'd like to have him finish his statement with the possible cost. I've heard rumors, but
okay. Mr. Sant, are you planning to discuss this with the board this morning as well?
I'm available if there's questions that would be appropriate for me.
I just want to make sure that we gave you an opportunity if you desired. Okay. So, Mr. Cameron, Commissioner Cook is asking if you could share with us those estimated costs, and I would add not just the cost for the initial action, but any potential appeal.
Yes, I previously told the judges that I estimate the cost, the cost from this point, that is, there has been about $4,500 in fees and costs incurred to this point. I estimate another $5,000 at the Superior Court level. I believe we can get a decision of the Superior Court. This has now been assigned to the Kittitas County Superior Court and a particular judge there. I believe we can get a decision of that court in 2 hearings at the most, perhaps 1 hearing. And so that's the basis for that $5,000 estimate. But then if the case is appealed, which is certainly a possibility, I estimate another $5,000 to get through the point where we have either a Court of Appeals decision or a Supreme Court decision, depending on which court it goes to initially. So I'm estimating $10,000 more if it goes all the way through a appellate court decision process.
And if it were to go to the state Supreme Court, how much would you add on top of that 10?
I'm including the Supreme Court because I think it's going to be an either-or situation.
Okay.
Either it will go to the Court of Appeals and end there, or it will go directly from Superior Court to the Supreme Court.
Okay.
Either way,
it's 10.
I estimate that additional $5,000.
Okay, so just to be clear, it's $4,500 to date, another $5,000 at Superior Court level, and then an additional $10,000, additional $5,000 for appeals.
Correct.
Okay, so that would, using the $4,500 to date, the $5,000 at Superior and the $5,000 at appeals, that would be $14,500.
Yes. And this is an estimate. We attorneys can't always predict the course that a given case will take, and there are sideshows and additional processes that can come along that require more attorney work. But as best as I can estimate, that's what I have.
Okay. Commissioner Cook, other questions?
I have none other at this point.
Okay, Mr. Cameron, you talked about the notion or the concept of shared costs between the counties. The the plaintiffs in this action are the 7 members of the Superior Court representing the Benton Franklin Superior Court, which is an entity unto itself, and the paperwork I saw was signed by all 7 judges. So whether the action directly affects things happening in Benton County or not, it does appear that the action, the plaintiff here, is the entire Benton Franklin Bi-County Superior Court system. Do you think that in any way speaks to or should impact who pays for plaintiff's costs?
My understanding is that each court, that is Benton and Franklin, stand on their own. Depending on where a given judge of this joint judicial district is assigned, he or she is acting for the Franklin County Superior Court or the Benton County Superior Court, depending on the jurisdiction of the case that he or she is presiding over. And that it is not an actual joint entity that operates in all respects as a single organization. And I think that the evidence of how many of the costs that I listed that are separately provided for by each of the 2 counties is the best evidence of how this is these are separate courts that they certainly share the county's half of the salaries of the judges, but with respect to these other things, they're quite distinct. And I think that since this issue only exists relative to Franklin County, because of its clerk's refusal to abide by the local court rule, it is one of those separate expenses, or at least analogous to one of those separate expenses.
Okay. What do you see as the path forward for plaintiffs if the county declines to fund a lawsuit against ourselves?
Well, I would certainly need to sit down with the judges and seek their counsel. I know, because there is case law that exists on this, that court rules which require city or county expenses can be enforced by the court at city or county expense. And I know you have Sean there. He may want to look at the case called City of Seattle versus State. And I'll tell this for him. It's at 100 Washington 2nd, page 16. And it's a case where the court, a court rule required cities to purchase recording equipment for municipal courts. And the city of Seattle sued, claiming that it was entitled to reimbursement from the state because of the statute that says the state is responsible for new expenditures required of cities and counties. But the Washington State Supreme Court ruled in that case that expenditures by a city or county that are necessary because of a court rule are the obligation of the affected city or county, not an obligation imposed by the state legislature. And I think that's an analogous situation here that suggests perhaps that the court could require this expenditure, but nobody wants to go there.
Okay. Mr. Kammerer, you started this conversation by saying that you were representing the judges. You are doing that under the authority provided when you were retained by Franklin County. Is that right?
Actually, I've been appointed by Mr. Sant as a special deputy for this purpose.
Okay, so my terminology was probably imperfect. I apologize for that. But in any case, you've been in writing provided authority to represent the judges in this matter, and I'm curious about that authority. Did it speak to limits on your role and what services you could or could not provide?
My understanding is that the appointment of me springs from the fact that the prosecutor can't represent and advise two conflicting offices that are associated with the county. And we attorneys have to be mindful of those potential conflicts, whether you're in private practice or in a governmental position. So that essentially I was appointed to do what the prosecutor could do if there wasn't a conflict in representing the Superior Court. And I sent Mr. Sant a letter dated February 6th of this year where I expressed my understanding of the nature of the appointment. And I'll just read the one sentence that concerns that. And it says, I understand and agree that I am being retained to represent the Franklin County Superior Court to analyze and advise, negotiate, and represent in legal proceedings, if necessary, the court as to issues surrounding the court's local rule requiring the county clerk to maintain paper records of proceedings in the Franklin County Superior Court. So that is my understanding of the appointment I received, in addition to simply being a special deputy prosecutor.
And
Mr. Sant did acknowledge and sign that letter.
So, what was the date on that letter?
February 6, 2018.
And you said Mr. Sant signed and accepted those terms?
Yes.
When was that? No, I think I just got handed a copy.
It was
the 7th?
February 7, 2018.
Okay. Okay.
Do you have a copy of that? Because I can certainly send that over.
No, I was just handed a copy. I'm just reviewing it quickly. Okay. Mr. Sant, we're certainly not, trying to conduct ourselves like a court and hear sides of an argument. We're just focused on the funding piece, whether Franklin County funds the defense of the clerk in this matter, I think is not in question. He's an elected official of Franklin County, and as I understand, we have a duty to defend him. So we can set that aside. The question here appears to be focused solely on whether or not we have a commensurate duty to fund representation for the Superior Court judges as plaintiffs suing the county. And I'm highly reluctant to spend taxpayer money on any litigation. We'll do so when it comes to meeting our obligations to defend one of our elected officials. It certainly gets gray for me in a hurry when you start talking about funding an action against ourselves, which is essentially what this would be. But the letter that I'm looking at here does say negotiate and represent legal proceedings if necessary, which would seem to cover what's being requested. So if there's anything you can offer that might help me differentiate, but it does appear that we've got a written agreement where we've said we would.
There is a couple questions for concern. One is looking at the shall authority of what the obligations of a prosecuting attorney are. As previously discussed with the board, we reached out to the State Attorney General's office. They're under the same obligations as we previously discussed. The Superior Court judges are dual officers. There's cases that make it very clear that Superior Court judges, because of their nature, they represent typically multiple counties, or they can represent multiple counties. The court opinions have basically held that they are state officers. They're dual officers. They're both a county officer, but they're also a state officer. We reached out to the State Attorney General's office to seek their assistance because, again, this is a conflict action between two elected bodies within Franklin County. It's clear that there would be a conflict in trying to determine which side we should represent. As we have discussed previously, the county prosecuting attorney is obligated to defend the county, defend its officers, defend its elected officials, as may be the case. It's an elective process, though, to initiate a litigation, and I recognize the language that both Mr. Kammerer and myself signed on to. If necessary, it becomes kind of, I think, an important question of whether or not it's necessary, because that could extend also, as Mr. Kammerer indicated, one of these parties is probably not going to be satisfied with the lower court's decision. So that would require it going on to appeal to a higher court and potentially the Washington State Supreme Court. Certainly the county legislative body, as well as a prosecuting attorney, as well as the State Attorney General's office, has the discretion to elect whether or not to initiate a particular suit. There's no obligation that I or any of my deputies that have the same authority that I would have would be obligated to carry a case forward. So we recognize that the state has declined to represent this case. Their explanation was similar to what we have previously discussed with the board, which is this is more of a plaintiffs-oriented case. It's a plaintiff's action. It was originally filed seeking damages. I recognize there's been an amendment that basically clarifies what relief is actually being sought, but nonetheless, it is a lawsuit against Franklin County. And that is a discretionary authority. We have to be legal advisor to the legislative authority. We have to be a legal advisor to other officers as well. But we are not obligated to initiate legal action. And so that is really the question. As I told Mr. Kammerer, I couldn't authorize further suit because I need to get any kind of authority for prosecuting the county. I would certainly need the board's discretion as the board's legal counsel. I would certainly need the board's discretion to authorize such a suit. One of the contemplations with considering the cost with any litigation is that if there's cost on one side, there's going to be at least an equal cost on the other side. And we are legally obligated to defend Franklin County and its members. That could include any employee of Franklin County if they were acting under their official responsibilities. So that places us in the position that we are, is that we initially offered to provide representation to the judges just because it appeared there was going to be legal action taken against the county clerk. We're obligated to defend that, and rather than to try to defend that ourselves, we recognize the relationship that we have with our judges as well as with our clerk on a regular basis. They're both essential for performance of our duties and responsibilities, and so we assigned conflict counsel to the clerk to guide through that process. I also extended an offer to the judges if they wanted to have an independent attorney as well to help facilitate a resolution. So now it brings us to the point that essentially we are looking at a lawsuit, and while not obligated to fund any lawsuit or litigation against the county, that's essentially the board's position. I guess the other contrast I would just bring to the board's attention is that previously we have other bi-county entities that you're well aware of, that we work with Human Services, other departments. Whether or not those particular actions might weigh towards a particular actions of one county or the other, certainly this is an action that has been signed off on all 7. It's very clear that this is a bi-county entity as well as a state entity. The state has exercised its discretion in not proceeding forward. The question now before the board is whether or not this is something that should be funded, and if funded, should that be borne solely upon Franklin County when it's being brought by all 7 members of the judiciary, in which we share a bi-county judicial district. So hopefully that gives a little bit of clarification. But
Yeah, that prompts a few questions. Commissioner Cook, I'll defer to you first, and then I've got a few.
Well, as we've said before, I would foresee no revenue coming from Benton County, period.
Okay.
If the shoe was on the other foot, it wouldn't have come from here, so. It's up to us.
Okay. So, Mr. Stamp, the state AG's office has declined to participate and represent the judges,
that's correct.
and you feel that this is more properly, given that counties are agents of the state, this is more properly a state matter? I don't want to put words in your mouth. I'm trying to make the connection here.
I think that the unique role that judges have, especially in our judicial district that encompasses 2 counties, it really places them as state officers. Now, they are both. Clearly, they are both. But the state recognizes that they have represented judges before when they are the defendants of actions, and the state AG's office has stepped in to represent them on those matters.
What was the basis for them declining this time?
Essentially, the short answer was that this is on a plaintiff's side, and they originally reached out to AOC, Administrative Office of the Courts, to see if they would fund out of their existing budget lines. I believe AOC, because they work closely with both clerks as well as judges, they probably chose not to do that just out of appearance sake. Whether they had budget authority in their line or not, I don't think they probably wanted to fund it out of their existing budget just out of appearance that might mean that they're siding with the judges. Regardless of their independent position, I think they chose to opt out of that funding mechanism, and the AG's office simply decided to elect its discretion action on situations like this, not to initiate the plaintiff's side of legal action, and chose to decline at that point.
So if I understand what you just said, it may be a combination of the 2, but whether they had the funding or not, they didn't see it as a proper role for them?
They saw this as clearly one that's of their discretion of whether or not to represent a plaintiff's action. They chose not to.
They didn't sense an obligation to do it, and they opted not to? Is that fair?
That's fair enough.
Okay, all right. What other options do you see for the judges if we were not to fund their legal representation? In other words, how do we resolve this short of funding their action?
And that might be a question we might want to take up in executive session, okay, because now we're getting into areas of particular legal advice.
That's a fair observation. So. You're right. The engagement letter of Mr. Kammerer does refer to negotiate and represent in legal proceedings if necessary. 2-part question: who determines what's necessary? Since we're the ones that are paying and you're engaging him as your special deputy, who determines when it's necessary, and is mediation a legal proceeding?
Mediation is certainly a remedy and an option there. It's not the one that's being requested, but it's certainly an option that's far from initiating a lawsuit against Franklin County. So it is different in that regard, is that is that it's a legal proceeding, I guess, in some respects. By simply hiring counsel to provide that legal advice, there's a legal component to that. Mediation.
Well, that's where I was going. Yes, we've consented to provide funding
Yes.
for mediation, which is a legal proceeding. So it seems that really what we're talking about is the distinction between what level of representation and whose judgment that accrues to.
Either way, if we were to proceed forward with mediation, that is going to be funding outside of, that would probably consume a lot of my professional services budget. So I guess the still question for the board would be, where is that funding going to come from? Because this is certainly litigation that was not contemplated in our normal course, and as Mr. Kammerer points out, it's difficult to, we could predict based on experience how many hours of service might be required to resolve a particular matter, but that's the question, is we don't have a definitive number. We can't really do that once we take a particular course of action.
I'm not looking for a particular number.
Yeah.
What I'm trying to drive to here is we've got a letter of engagement that says, including representation in legal proceedings if necessary. What qualifies as a legal proceeding? It sounds like to a certain extent mediation does. And who makes the judgment as to when and if it's necessary? And I anticipated that you would say, as a special deputy appointed by you and working under your authority, that decision authority would rest with you. But, you know,
well,
we've got plenty of lawyers in the room, and I'm not one of them, so you tell me.
Well, that's certainly a question, because obviously, let's say the decision was determined by a deputy in my office to take a matter. Obviously, that is under my authority. They're acting under my authority. If it was determined that we need to litigate this all the way up to the U.S. Supreme Court, that would be a substantial cost to the taxpayers.
Sure.
And so certainly I believe it would be retained with the prosecuting attorney to be able to weigh in on just what is determined as a necessary legal action. In this particular case, because it's in the nature of a lawsuit, that is not something that I am obligated to take on. So likewise, it's not necessarily an action, it's an elective action, but I'm not trying to present to the board today that it's an improper action in any way, and I shared that with Mr. Kammerer as well, is that I recognize, because of the unique nature of the disagreement, I recognize the nature of the filing of the writ that was done. I certainly recognize that as being a remedy option for a situation like this. It really comes down to the funding issue.
So let me just ask then, is it a viable option if the board were to decide that our first objective is to represent, protect the interests of Franklin County citizens, which happens twofold. One is the pursuit of justice in addressing a legitimate question, and two, doing it at the least possible cost. If those are, in fact, our goals, might the board authorize funding for mediation and withhold or postpone a decision on any other funding pending the outcome of mediation? We're not judges, and this is not a court, and we're not in a position to direct anybody to follow a particular course. You know from conversations that we've had on unrelated matters that courts do oftentimes in civil cases, direct mediation. If we have that opportunity here, it seems to me that in the pursuit of those two goals, protecting the public interest from a justice perspective and also minimizing costs, that might be a proper path. Do you have thoughts on that? And then I'm going to ask Mr. Kammerer the same question.
I was just going to say, I think on this particular case, because Mr. Kammerer is specifically involved with the relationship of the particulars of the parties, I'd probably defer to him first for his insights to how that would be suited in this particular case. Me personally, obviously, and all the other litigation that we've been involved with on the civil side, mediation is certainly a route we try to pursue if we feel that is something that's likely going to be of the citizens' best interest, reduce cost. So I would really want to defer to Mr. Kammerer on the particulars on this case. This is a little bit different scenario in some respects.
Well, it does occur to me that the differences between the Odyssey system as it stands now in Franklin County and the what I believe to be the expressed desires of the judges for that system, the delta, the gap between those two is not so great that it couldn't be overcome with some effort and some funding, and I would anticipate significantly less funding than a legal proceeding would require. So again, if our two objectives, and I believe they are to seek justice and defend the public's financial interest, then mediation seems to me the responsible path. Mr. Kammerer, your thoughts on that, if you would, please.
Thank you. First, let me clarify about the damages issue that came up. We carefully crafted our pleadings in this case to avoid any mention of a request for damages. We are not seeking money damages from the county, the clerk, or anyone. We simply want the clerk to be directed in an unequivocal manner to abide by the local court rule. And we even, in filing an amended complaint, eliminated the usual boilerplate language about recovery of costs and disbursement from this complaint. We eliminated that usual language, which is always even when costs and disbursements are awarded, a minimal statutorily limited and specified amount. So there's no risk of a money judgment against the county or the clerk in this litigation.
Thank you. Thank you for that clarification. I don't think anybody on the board or with the county staff was of a different view than what you just expressed. I think the judges have made that clear, and I appreciate you reiterating it for the public. That is
bent over backwards to avoid that implication.
Right.
We wouldn't want it to be misunderstood.
And
in terms of mediation, mediation usually takes place within the context of a lawsuit. Either the parties agree to mediation or the court directs mediation, but it occurs in the scope of a lawsuit. And mediation is simply negotiation. It is not something that can direct either party to agree to anything. And we have already gone through that. The court has attempted to reach agreement with the clerk over the control of the court's records. But an essential part of this is that the clerk will not and has refused expressly to recognize the court's authority to control its records. So this would allow him to say he will negotiate, but he will retain the unilateral ability to thwart the needs of the judicial system as decided by the judges who are responsible for that system. And so mediation with that condition implicitly imposed, and actually expressly imposed by the clerk's refusal to follow the court rule, will mean that mediation will fail. And therefore, the costs of mediation will be incurred. And at the end of that unsuccessful process, we'll have to go back to court. The best way, the least expensive way to get this resolved is to go directly to court, ask the Superior Court judge in Kittitas County to review the legal authorities and order what we believe will happen. We'll order the clerk to abide by the local court rule. That will cut through all of the posturing and misdirection that we think is involved with the clerk's refusal to accept the court's control over its own records. So we would argue against heading off on a branch called mediation.
Well, it would seem that mediation can be done outside of a lawsuit, certainly on a voluntary basis, but I take your meaning as to your view of the likelihood of that being fruitful. I know that you don't intend to speak for the clerk and how they might or might not participate and what position they might or might not take on this day as opposed to some previous day.
May I say one more thing?
Sure.
I don't know whether you will have a discussion like this with the clerk, but please ask him, do you accept the local court rule concerning the provision of paper records to the court until the court is satisfied that the Odyssey system is sufficient to rely on exclusively? Any answer other than yes is the true indication of why we need to go to litigation.
Okay. Mr. Sant or Mr. Kammerer, either one, is there any kind of an objective state standard as to what constitutes a fully functional and reliable Odyssey system, since that is a statewide system, or is that a local interpretation that could vary in all 39 counties? If there is a statewide benchmark that we can look to, then that might be a path for us. Thoughts?
Well, if I could go first, I'm happy to hear Mr. Sant's opinion on this.
Please.
Because I've looked at the Odyssey system and used it from a practitioner's standpoint. It appears to be different, at least slightly, in every county that I've worked in. And some of that has to do with things that are influencing the Franklin County Superior Court's position here, and that is the physical facilities that enable them to access, or in some cases not access, the electronic system. And so some counties may have physical circumstances that allow that access everywhere the court functions, and others don't. And I think that how what they call workflow procedures are organized using the electronic system, or in some cases needing to resort to paper records, will be dictated by local circumstances. And so I imagine someday in the future that all courts across the state will work the same way, but it's not there yet.
So if I may summarize, what I believe I heard you say was that geography and judge preference by county can shift the definition of what is a fully functional and acceptable Odyssey system.
And physical circumstances.
Right, that's what I meant by geography, sorry. Geography within a courthouse, for example. I would much rather spend money on infrastructure, computers, networks, and whatever's necessary to make Odyssey readily available wherever the judges need it than certainly to spend it on court proceedings, because we're going to adopt Odyssey eventually anyway, and we're going to incur those expenses at that time. If those expenses can be incurred now to resolve it, then that's certainly a preferred path. I understand there's still the remaining issue that you cited, which is whether or not the clerk is willing to acknowledge an obligation to abide by the court rules, and I'm inclined to think that that's certainly not something we're going to solve here. Commissioner Cook, we've got a request for funding. There's no specific amount attached. There are some cost estimates that obviously estimates are not entirely reliable. It seems to me that our options are to approve, decline, or defer. And deferral, in my book, would look like an opportunity for a week or so to investigate other remedies, not trying to run a court proceeding, but just looking for a more cost-effective commitment between the parties here. It's pretty clear what the judges want. I haven't talked to the clerk, It sure would be nice if we could resolve this at less cost and obligation to the citizens, and before we funded a trial against a lawsuit against ourselves. I'd sure want to feel like we exhausted every other possibility. That's kind of where I'm at. What are your thoughts?
Well, I would have to agree with that. I think we need to hear what, if any, opinion the judges have as far as what would take to bring it up to where they're comfortable with the
Right.
the software, so to speak, or the access to it.
Well, that's because we've committed to Odyssey. I think that's the cost we incur no matter how this goes forward, no matter how it resolves. We eventually are going to have that cost. I think the real sticking point likely here is whether or not there can be professional agreement on whether or not the clerk is obligated to adhere to court rules. That appears to be a hard point with the judges. I would think that deferring funding for a week, let's say, to give the parties an opportunity to consider whether or not, an opportunity for the judges to tell us what additional infrastructure, computers, et cetera, they would need to meet their needs. In other words, define for us what Odyssey has to look like for it to meet your needs.
Right, that's what I was getting at.
Okay, and then for the clerk to have a final opportunity to acknowledge what his position is, because we've not had an opportunity to discuss with him. I don't think that I'm known by anyone as a person who likes to kick the proverbial can down the road. I like to deal with things head on, but in this case, I think there's maybe an opportunity for us to resolve this short of the citizens of Franklin County paying for a lawsuit against themselves, which I find offensive in its nature.
Would like to ask a question, Mr.
Sure.
If the board's choosing to defer complete action, that's certainly understandable, but would you provide me direction on the services that have been billed to date? It seems to me that at least Mr. Kemmer operated in good faith, understanding that you would be compensated for that.
Yeah, I don't think there's any question there.
Exactly.
Yeah, we've got a letter of engagement. It's signed by Mr. Kemmer. It's signed by Mr. Sant. That's, I think, clearly a financial obligation the county must pay.
And I think this is just very possibly ongoing. It's not necessarily going to finish.
Right.
And just for the board's clarification, I did explain to Mr. Kemmer that, of course, all the funding to date would have certainly been covered. I informed Mr. Kemmer that I couldn't authorize the litigation prong of it, meaning that certainly that would open up for other avenues if there's other discussions. But just for clarification, Dale, wasn't that your understanding as well, that there was no question about any prior services rendered, whether payment would be made? It was just the ongoing funding of the litigation.
Well, yeah, I think in my last bill I had several items where I just decided not to make any charge for because of your suspension of my representation, and so I appreciate the boards and your willingness to pay me for the work I've been doing since then. So yeah, I'm satisfied with the situation.
Okay. Well, I think all things considered, our first duty is to the citizens in trying to resolve this at a lower level, at less cost, without the citizens having to sue themselves, which is effectively what's happening. I think we defer this at least for a week so that we can get a better definition, frankly, a clear picture of where the parties are and how big the delta or the gap is between. I leave open the possibility and the hope that one or both of the parties will acknowledge that while they may have a perfectly legal and ethical position that they're defending, that sometimes discretion, as they say, is the better part of valor, and relenting in their position for the benefit of the county is the more appropriate course. So I think I'd like for us to take a week to see if that opportunity exists before we take this any further. Mr. Kammerer, do I need to clarify that any, or was that sufficiently clear where the board is today?
That's clear. Thank you for the opportunity to listen to me.
Okay, thanks very much. Mr. Sant, anything else before we disengage Mr. Kammerer?
Nothing further. Thank you.
Okay, so with that, we'll be finished with this topic, and Mr. Kammerer, thanks very much, and we're going to go ahead and hang up now.
All right, thank you. Goodbye.
Thank you.
Thanks, Dale.
Okay. Mr. Johnson, any other administrative business for us?
Not today. I do have a request for executive session following your public comment.
Okay, are you anticipating any action following that executive session?
No.
And for the benefit of those that are here that may not want to wait, what is the nature or the RCW for that executive session?
It is under RCW 42.30.110, paragraph 1, subparagraph G. Evaluate qualifications of applicant for employment or review performance of public employee.
Okay. All right. Commissioner Cook, are you anticipating any other action items today?
No, I have nothing else today.
Okay. I too have no other topics or actions for the board today. So it appears that the only two things remaining on our agenda today are public comment, which we'll do next, and then an executive session, after which we're not anticipating any action. So, with apologies for the delay, but that long conversation was detailed and necessary. This is an opportunity for public comment, and understand there's no other actions other than executive session for today's meeting. Anyone wishing to comment, now would be the opportunity. You're not obligated by statute, so far as I know, to identify yourself, but we always appreciate that courtesy.
I'm Brenda High. I'm representing Precinct 71, the Republican Party. I'm also representing Precinct 100, LaWanda Hatch, who had to leave, and she asked me to read this message, and it had to do with the possible redistricting of the commissioners' lines. I am the precinct officer for Precinct 100. I represent a lot of farmers. We have had such a little voice, and we count on having at least one commissioner that will represent us. The city residents have city council, the mayor, and the county commissioners, and we only have one county commissioner. We ask that you reconsider heavily your desire to redraw large boundaries for the commissioner's district. And as the representative of the voters in 71, which would also possibly be affected, we also would not approve anything happening, at least until after the election. And just one little comment on the judges. I think you should pay the doggone judges, and I hope they remember that at the next ticket I get. Thank you.
Okay. Anyone else wishing to speak with the board? Comments?
Clint Didier, farmer, 8 miles north on Glade Road. Again, I want to bring up the issue of this redistricting that was brought up, and I have the minutes of April 3rd after listening to the audio that is sent to me, and I asked the public here that are in the court, in the room here, to request that you also be sent the audio from the commissioner meetings. I requested it, I'm receiving it, and I'm the only one receiving it. Everyone should be receiving it. It should be easily accessible from the site. Now, the audio of April 3rd was very lengthy on this redistricting, but in the minutes it says the commissioners held a brief discussion on commission districts. Potential action will take place at a later date. I strongly oppose this. We have the census coming up this year. If we redistrict now, and the census comes out with other numbers than what you're going off of the last census, we'll be right up against it again. Did it again. I strongly urge you not to take any action on redistricting this term until after the election, so that the public may have a voice in this. Also, I understand that last meeting in the minutes, there was no mention of public comment on this until today. It was put in the minutes. It looks as if there is some maneuvering here to keep the public uninformed. I strongly suggest that you do not do that either. There will be a wrath from this North County of farmers that want to be represented here on the commissioners. Thank you.
Matt Beaton, County Auditor. I spoke last week, and I'll speak again. I'm hearing from people in the interim about these very same issues. They are concerned. I do know that it was brought up that there was no reflection of any of the public comment, at least on this issue, in the meetings, and that was fixed, and it's, in fact, a change that's going to be made going forward. I do hear from people that are, this is redistricting is a highly charged, and typically the public feels very strongly about it. And, on April 3rd, an unscheduled discussion was had. A law was cited that was either erroneously cited. Draft maps were made. And so people are kind of wondering what's going on here with this tight time period. I said it last week. I'll say it again. The public wants to be involved in this, and for one reason or another, they're suspicious of something going on. And while it's a tight time period, I'm not. I just want to encourage what I read last week, which is the openness and transparency if there's going to be changes made to the district boundaries. Thanks.
Okay, anybody else wishing to comment?
I'll keep this brief. My name is Taylor Taranto. I'm also for the postponement of the redistricting until after the election at the very least. Thank you.
Okay, anybody else? Okay, well, we'll go ahead and move past the public comment period. Thanks for taking time and sharing your views. Commissioner Cook, any comments, anything you want to say before we move on to executive session?
Nothing.
Okay. I'll just, for those of us, or those of you who have expressed concerns about redistricting, in a previous meeting I did read verbatim from the statute as to where it says shall versus should and what the requirement is. I did that for the benefit of people working from facts. And I also highlighted the recently signed by the governor law that goes into effect in July, the Voting Rights Act for the state of Washington, which is going to deliver to us redistricting. Opening the conversation and discussion with the board did not necessitate, nor was it necessarily intended to drive us to a redistricting before the election. It could. It would be perfectly lawful. But I don't have any issue or concern about delaying that process. I'm not advocating for us redistricting at this point. And I think you can anticipate that unless something significant should change or should come along, that you probably won't hear me talking about redistricting further. It is worth noting, however, though, that if you've not read the Voting Rights Act, you should. What you're going to find, I believe, is that there's a very clear process that will take us into a redistricting process, and the timing of that may be more or less convenient than doing it now, but I'm not hard over on the notion that it has to be done now. And as for the suggestion that maps were drawn up, actually one notional map was produced in a draft form, not presented for public or for formal consideration, and it was presented as this is something that would likely comply with the Voting Rights Act. It wasn't necessarily, this is what we ought to do. It's, this would comply, something to consider, read the new act. So for those of you that are interested in really focusing on complying with the new law, I think once you read that, if you, and maybe you already have, you'll see how that all fits together very accurately. And I don't think that there's probably anything else really for us to discuss at this point on redistricting. I don't anticipate it happening prior to the election, and I'm not necessarily advocating that it should, only pointing out that it lawfully could and would allow us to comply with the Voting Rights Act before it was done for us. So enough on that. We'll move to executive session. It is 10:26, almost 10:27. Mr. Johnson, how much time do you need for that?
Only up to 30 minutes.
Okay, this is up to 30 minutes, and we'll start at 10:28, we'll call it.
Thank you. Yeah, I would like just the board, the clerk, and Carly, the HR director, to be in the room.
Morning, Fred. Mr. Sant, Mr. Didier, if you clear the room, please, so we can do our executive session. Okay, it is 10:57. We have concluded our executive session, used the full allotted time. We're back in open session now. Prior to the executive session, we noted for the record that we didn't anticipate any action, and while that was accurate and true, it doesn't preclude us, if there is any other business that needs to be conducted, we could take that up at this time. I don't have anything, but I'd like to make sure no one else does before we...
I'll be leaving tomorrow afternoon for crab board in Olympia for tomorrow night, Thursday and Friday.
Okay.
I will be at the meeting next week, but plan on leaving after that meeting for the county administrators meeting in Leavenworth for 3 days next week.
Okay. Carter, anything?
No.
Okay. Karen?
Will be absent next week as well, I'm sure.
Okay. Yeah, sure we'll be filling in. Okay, well, if there's no other business before the board, then we are adjourned.